Good morning and welcome to another exciting edition of Business Law. This week of started September 14th yesterday. Today's the 15th, midway through September. We're midway through our fourth week actually of the semester. It goes by fast. Counting down, that leaves us with 11 and a half weeks remaining. Amazing. We still have a lot to get done, so well, let's get started here. First, let's take a look at the discussions, kind of see how they're coming along. I'd say my overall impression is fairly well. If I'm encouraging you to do anything, it's to start looking ahead at some of the other chapters, maybe, when we're talking about the NLRB ruling here too. You might look ahead to labor relations that we have, and that's quite a bit later in the book, right? But if you really want to add some stuff that's relevant, you might take a look through that and see if there's some pertinent information that we could add to this particular discussion. You might also do some other searching, not just for this case, but I think for all of them. What I'd like you to do is get outside. Are there other cases or anything that might be similar, that might have an effect, other rulings that the NLRB has made, other issues, other articles, other points of view. You don't necessarily have to come up with a point of view by yourself. It could be because of things that you've read or looked at, and you might want to, and I would encourage you to share those with us. There's lots of websites, and of course you guys know how to Google or Bing or whatever and look it up. You might find all kinds of differing opinions on this subject and what it might lead to and whatnot. And I'd like to see that. This one, I imagine, because it's kind of new for you guys. You don't really know how the NLRB works and different things like that, and what issues they take into consideration. And this ruling is a little more complicated. It's probably more complicated than what I really wanted, for this point in the class. Might have been better for later in the class, but I thought it was a good article, and it was timely because it just happened, and so that's why I wanted to present it. But the issues here, again, I think they get deeper, and that's why I'd like you to do a little research, go outside and see what other people are saying about it. First we kind of started into the minimum wage thing, which this really doesn't have anything to do with, but but then it got into, and appropriately, it's gotten into the union side of things, and that's very appropriate. Okay, that is a part of this particular ruling, that it might enable employees of, say, all the McDonald's in the U.S. to form overall a union. Putting that together might be kind of difficult to do the voting and whatnot that would be required, but it's a possibility. It might be that they would unionize in geographic areas or those types of things too. Those types of things can happen. I think in the past where they've had any problems is if a local one wanted to unionize, that was okay. They could vote and whatnot then, but that might just affect one restaurant and not any of the others. So that's one part of the discussion. It's broader because the ruling the NLRB made here says that contractors, franchisors, those folks that use other businesses, let's call it, below them, like subcontractors or franchisees, that the head business, the general contractor or the franchisor, might be responsible, in fact will be responsible for the actions of the franchisee or the subcontractor in regards to their employment practices. They might be responsible for dress codes. They might be responsible for what's allowed and what isn't, and hours, and who gets paid a salary and who doesn't get paid a salary, and so I think there's a lot of things that this ruling might affect, and I, if you guys do a little research and expand onto that, I think it would make the discussion a bit better. Next week I got Judge Block's new federal rule on Ooh, yeah, yeah, that's the waterway one. And there was just another article in the newspaper. I think today I was reading about it that there's a Republican, it's either senator or congressperson, who wants to impeach the EPA director as a result of this, not as a result of the rule, but as a result of her testimony in Congress regarding the rule. Claims that she perjured herself. Okay, so this one's very broad too, and this one for our area is hugely impactful. Is that a word, impactful? Oh, I hope so. But the reason is because it takes waterways and it expands that definition to what occurs naturally and sometimes unnaturally on a lot of our farms and ranches. Puddles, water holes, um, even little dams and whatnot, wetlands and those types of things that maybe heretofore have not been regulated. And while initially you look at it and they say, yeah, that doesn't necessarily mean anything. I can sure see this as a conduit for regulators to tell farmers, ranchers what kinds of chemicals they can or cannot use on their properties. And to a certain extent, they can do that now, but I sure see that role expanding greatly. Um, and so that could be a very interesting ruling. Now, at this point in time, this judge, issued an injunction, I think, for the 13 states that were suing, meaning that the EPA can't enforce it for the time being, right? And that's kind of where we're at with that one. But believe me, it's been in the news and will continue to be in the news. I'd encourage you in the discussions. Again, you don't have to limit yourself to when your group is doing the discussions. You can comment on any particular subject. And two, please submit to me your ideas for other subjects. I have a few in my key right now. I'll kind of show those to you maybe. I think I've got good enough definitions here. You guys might be able to look at the locker here too, and that's fine. I'll see how, the Texas high school football players who tackled the ref. Yeah, that one's kind of interesting. And then a student, one of your classmates, sent me the Montana doctor charged with 2 counts of negligent homicide. Kind of interesting. That looks like overprescribing of certain drugs. And then this one hit yesterday, and I think it's kind of funny. Dancing baby and the fair use doctrine. I think we'll find that one kind of fun and kind of interesting, and it'll open our eyes to another subject when we talk about copyrights and those types of laws that people deal with. So be on the lookout, and click on a few headlines, because you never know what the articles might bring up. Go use some sources. Go to Drudge Reports, one of my favorite, DRUDGE. It's just an accumulator of headlines. It tends to be kind of conservative. I also, though, look at the New York Times. I get an email from them every morning with certain headlines, and I can read articles. That's where that baby dancing one came from. It tends to be very liberal. Fox News, USA Today, any of those, they accumulate and offer you some headlines, and it's all for free. And some of the major publications, Wall Street Journal, you can't get for free, and Financial Times, and there's some that do have some interesting articles, but we can't get those for free, and we probably don't need to. We'll find plenty of subject matter out there, and some of the local resources, right? Even looking at the Havre Daily News, like we found with the roof, the wrong roof torn off, or the Montana doctor with the homicides. I think that article might have come from a TV station actually, but certainly could have been in newspapers as well. So local, Great Falls Tribune, Billings Gazette, Havre Daily News, Missoula, whatever theirs is called, the Sentinel or something. Lots of resources, so go ahead and use those, okay? Please do that. So assignments coming along good. I know I just last night kind of got through, what was it, week 2, if I'm not mistaken. Yeah, got through those pretty well, and they were done well. I found a few errors. That's you were writing quite a bit there. A lot of you did anyhow, and just a couple of writing errors and whatnot. But otherwise, everybody did a pretty nice job of answering those questions. So keep them coming, keep them good, okay? Keep working on them. I think the quizzes are coming okay. I think you're finding the quizzes to be difficult. They are, okay? Remember that they're open book, okay? Get your book out and read it beforehand. Read the chapter before you start the quiz, and then have your book ready, and then you'll know where to refer back to answer some of the questions that might be in those quizzes. So I think we've got a little time left for our second test. I gotta see. Okay, yeah, it'll be here towards the end of September. We'll have test 2, so a couple weeks, and that one will be coming up. So let's. Oops, where am I going? I wanted to come down here, and now we'll talk about the litigation process. Chapter 4 is where we're up to. So. This is some of the procedural stuff, right? Some of the procedural law that we talked about, right? And the processes that we go through, right? And we like to believe that we have an impartial enforcement of disputes and whatnot that go on in the U.S. And while we could often argue about that, and we would often argue about rights and wrongs in a lot of individual cases and those types of things. If you looked around the world, again, I think you could hold our system up to any system in the world and say that it's really pretty good. Okay? It's far from perfect, but it's closer to perfect probably than just about any other system in the world. We seem to do our best to try to right wrongs and to try to keep the playing field relatively level and do some things like that. So it's kind of like referees in a football game. You love to yell at them and accuse them of making bad calls and this and that, but the game wouldn't be so good if you didn't have the enforcement out there. And we often, we'll watch a game and we'll criticize a call and whatnot, but we also realize that probably 95% of the time they get them right. It's pretty amazing. Watching baseball now, watch the ump behind the plate, and they, now have the little rectangle up there that shows where the ball passed the plate, and it amazes me how often, the umpire behind the plate calls the correct call on a ball or strike. It's astounding that they do as good a job as they do, and our judicial system is much the same. Not without some conflict, not without some troubles here and there, but for the most part they do pretty well. So the parties in cases, this could be criminal and or civil, right? It could be we have a plaintiff and a defendant, right? So the plaintiff files a claim or a motion, maybe, or a charge, okay, kind of depending on the type of case, and the defendant then has to answer, and we'll talk a little bit more about that. Then, of course, you can have counterclaims, right? And you'll see this often in civil cases. Maybe a couple of companies or whatever are getting a little bit of a peeing match, and getting after it a little bit, and one will sue the other, and the other one will sue the other one back, right? So then you have a counter plaintiff and a counter defendant, and we don't talk about those too much. I don't think they're on the test or whatever. And then, of course, the loser in a case, be it the plaintiff or the defendant that lost at an initial level, can become an appellant, right? And then the other party becomes the appellee. Petitioner and respondent, I see these in divorce cases. My guess is rather than calling it a plaintiff and a defendant, they've just come up with a different name, maybe to take the edge off a little bit. So it's called a petitioner versus a respondent. I don't know that I've seen it in other cases, maybe other family matter types of cases. If a child wanted to be free from his or her parents, they might have something like that, but usually that's where those show up, and the petitioner is the person asking for the divorce, and the respondent's the person, and then we come up with an answer. And a third-party defendant, and I think you guys had homework likely that had to do with third-party defendant and what why that would be, and it's relatively simple, that a third-party defendant is just another person or company, entity that's brought in because the full extent of the claim can't be decided by just the parties that are involved. And for example, and we'll use big companies, but maybe Walmart sells bikes made by Schwinn, and so Walmart sells a bike and they sell a bunch of them, and the bikes start to go bad, people are getting hurt, and they sue Walmart, and Walmart says, well, wait a minute, we're just selling the bikes, and we need to have Schwinn in as the third party. Okay, and that would be an example of how that could happen. I think the plaintiff could also bring in a third party too. They might sue Walmart because Walmart sold it, and Walmart didn't exercise due care, but they might also name Schwinn, right? And so you'd end up with a third party. So getting into court requires all three of these. There has to be standing, which we'll talk about. There has to be a subject matter jurisdiction. Again, we'll talk about it. And there has to be a personal jurisdiction. Okay, and it takes all three to get there. So what's standing, right? You must be involved, in the actual case or controversy, and the plaintiff must have a personal stake in the resolution. So I can't sue somebody because they hurt my buddy, right? I don't really have a personal stake in it unless I was hurt as well. Okay, but I can't sue them even on behalf of my buddy. Okay, now if I was, if my buddy's wife could sue on behalf, because there would be a personal stake then in the resolution, right? If my buddy got killed or something. Okay, so you have to have that kind of a personal stake, and I think interesting case, I think it's still in the book, was in an older version of the book at least, was Need Now versus some school district, I think, and the case involved a fella who he was upset that his daughter was required to say the Pledge of Allegiance and that it had the words "under God," and it was kind of interesting following that in real time, because it went all the way to the Supreme Court, and everybody at the Supreme Court, or everybody following the case, was thinking, good, the Supreme Court's finally going to issue a decision regarding the constitutionality of saying "under God" in the Pledge of Allegiance. And so the court convened, and they heard the case and everything, and weeks later they issued their ruling, and the ruling was, the fella, Need Now, didn't have standing to sue. And it turned out that he and his wife had been divorced, and his wife had primary custody of the child, and so the court just said he doesn't have standing. Okay, so it's really a decent case that illustrates then what standing might involve. The wife, she had no interest in pursuing the case. Okay, the daughter may or may not have even, but of course she was young. She was under the age of 18 and couldn't have pursued it on her own anyhow. So I think that case really illustrates and gives you a pretty good idea of what standing to sue kind of means. Subject matter jurisdiction. Now, a lot of courts are courts of general jurisdiction, meaning they cover a broad range of things, but different cases, something that might happen, for example, in Havre, I think I've talked about it, banks are federally protected, right? And so, if you robbed a bank in Havre, well, it's in the city limits, and you would think that might go to the city court or maybe even the district court, right, because it's felony. No, it's a federal court thing, right? So that becomes a subject matter type of a deal. The type of crime, kidnapping too, is considered a federal crime, and thus the feds would step in, and that would be adjudicated in a federal court, not in any kind of a local court or anything. And so, and there are also special cases. When you guys took a look at our court system in Montana, and maybe that was a part of this assignment too. That was probably last chapter. But we have water courts and we have workers' comp courts. We have separate courts, right? They're going to deal with those issues, and so they wouldn't come up in justice court or municipal court or city court or district court, any of the above, right? So we talk about those subject matter things. Yeah, they've got specific courts in some bigger cities. probate courts that dealing with people that have passed away. Traffic court and federal courts have jurisdiction over certain things. We don't have separate traffic court in Havre. Okay, we don't have a separate probate court that I'm aware of. Those are handled. Probates are handled at the district level. Traffic court was handled either at the city or at the county. City court, justice court, possibly at the district level, depending on, I suppose, the offense maybe. Personal jurisdiction might have to do more with the geography, right? So did the crime occur, or does the case have a bearing or parties, or that it lived in that geographic area covered by that court? Okay, and the court can have authority, and summons and services can be sent out. There's the long arm statute which says you can extradite, or you can ask people to come back and be held accountable. So if somebody commits a tort, say in Havre, they hit and run, right? They hit your car, they run, they take off, and they go back home to Spokane or something where they were from. Can the court still serve them? And there's long arm statutes that allow that to happen between states. Might the person be, have to come back and be held accountable? Yeah. They might work something out at distance too. The guy, depending on the severity of the case, whether it's felony, misdemeanor, it might just be a civil case, could be both, of course. And so the person can be held accountable, could be dragged back if need be. So again, standing to sue, I think I get ahead of myself here, right? You have to be involved in, you have to have personal stake, there has to be an adversarial. Subject matter, got ahead of myself. I already talked about all these, but probably helps if you guys look at them in the PowerPoints, which you guys can open up, right? We talked about diversity of citizenship, and so if the amount is big enough, I think 75,000 is the limit. Then the case is going to go to a federal if there is diversity of citizenship between two states. If I'm arguing with my cousin that lives in California over something that's, maybe we entered into a deal, business arrangement together or something, and it's $200,000, right? It's big enough that if we take that to court, we might well end up then in a federal district court, okay? Because of the diversity of citizenship. And then, of course, federal issues end up in federal courts. We have two, and in fact, I was just seeing that, what the heck tribe was it? Over west, was it Flathead? And they issued an order that is kind of interesting, that drug dealers were no longer allowed on the reservation, and they called them undesirables. It's what the tribe called them. And in the article, they said that one of the reasons they were doing that is because the federal government hadn't exercised proper authority over the drug dealings that were taking place on the reservation, because tribal things and land and whatnot is held in trust, and so the federal government has certain authority, beyond tribal government itself, but they have certain authority over things that happen on reservations too. So we kind of have that going on in Montana. It's not unique to Montana, but might be a little more common in Montana maybe than some other places. Personal jurisdiction, submission to the court's power, venue. Again, it means that jurisdiction's there. If you follow the Baltimore case, was it Freddie Gray that died at the hands of 6 police officers. Apparently he was roughed up a little bit, created a big old stir in Baltimore. They had protests, and then more people died because of the protests and whatnot, and everything got out of hand. They had to move 3 games, Orioles games, to like Florida on account of the craziness that was going on. Anyhow, the defendants in this case asked for a change of venue. They felt that to be tried, and the defendants are the 6 police officers. They felt that to be tried in Baltimore, they couldn't get a fair trial because there's been so much news, so much publicity, so many protests and those types of things that they couldn't find an impartial jury amongst the million or so people that live in the area. Just recently, just in the last day or two, I saw that the judge had denied that request, so the trial will take place there in Baltimore. Okay, summons, again, we can summon people to come back to the court's jurisdiction, right, and be subject to it. Okay, long arm statutes say that, you know, we can go get them, right? If the tort was committed within the state, again, like the car wreck example I was talking about, if property that's you're in dispute maybe is within the state, then it's going to happen, you know, at the state level, right? Or if the transaction occurred within the state, so if you bought something, you know, in a certain place, it might be subject to the rules and regulations of that. We can extradite folks. Okay. You know, often, if it's a smaller civil thing, okay, what would often happen is you'd probably summon the person. You know, if they wrecked your car and it was $1,000 worth of damage, you wanted them to come back, they'd probably get summoned. They'd probably get ordered to come back and appear before the court and whatnot, and they probably wouldn't. Okay, and what would happen then is the judge would enter an order of judgment by default on your behalf, which would give you then some authority to go and collect from that person. Okay, I mean, in practical cases, that's kind of what would happen for smaller amounts. Okay, bigger amounts might get to be a little different, of course. Class action suits, right, filed on behalf of all with a similar claim. That's what the Ashley Madison lawsuit's about, right? There were more than one person. You know, it ended up being many people, of course, that were affected by the breach or the hack. And so I believe it's a class action lawsuit then, if I'm not mistaken. It might have just been the two defendants, but I think they named the two lead defendants, and then everybody else is a part of the class or class action, right? Notice given to all members of class. You know, I've been a part of them and gotten notices, and maybe you guys have too. In my life, probably a couple dozen, no, maybe a dozen. Different times when you open up the mail and you go, what the hell's this from? You know, one was a motel my wife and I stayed at in Las Vegas one night that supposedly overcharged us. We couldn't even hardly remember that we stayed there because we were like passing through, I think on our way to Phoenix or Yuma to visit my mom. Hardly remembered staying there, you know, and yet we get this thing in the mail that they were being sued because they overcharged us and la da da, you know, and I find them interesting and kind of fun to follow sometimes. You know, honestly, in many cases, you know, the reward or award that you get as being a part of the plaintiff is very nominal. Years and years ago, there was one for Sears Mortgage that my wife and I had a mortgage that was being serviced by Sears Mortgage, so we were part of it. And literally, our settlement, I think everybody's settlement was similar, if I'm not mistaken. Honest to God, was 25 cents. And they had to send out a check, and even then, the price of a stamp was more than 25 cents. So it cost them more to send me the check than what the check was for. You know, why I didn't keep the check, I have no idea. I guess I just wanted to cash it for whatever reason. I didn't need the 2 bits, but it was just funnier than hell. Now, on the other hand, does that seem kind of crazy and goofy? And the lawyers were rewarded well. You know, they made a lot of money out of the deal because they represented the whole class. But on the other hand, I can remember at the time that Sears Mortgage was nasty in how they were handling mortgages, and it related to how they were handling escrows or set-asides for the payment of taxes and insurance. They were just being nasty. They were horrible, and I knew that, one, because I had to deal with them personally, but I also had to deal with them at the bank, and it was horrible. And so they needed to get knocked down. They needed to correct their actions and how they were doing it. And so, you know, while it's easy to laugh sometimes at these settlements and whatnot, and also kind of feel that some of them are stupid, and some of them are. Don't get me wrong, there's some of them that are just horrid, I think, and really crazy. But on the other hand, there are times when these companies have misbehaved, and if we didn't have our court system and the attorneys, you know, some of the wrongs wouldn't get righted, and some of the companies would never change their actions. So I'm one of those that's kind of in the middle on the subject of trial lawyers and these kind of class action lawsuits and those types of things. So we got pleadings, pre-trial motions, discovery, pre-trial conference, the trial, okay, post-trial motions, appeal. You know, these things take a long time, right? And And there are cases that seem to drag out, and they seem to oftentimes be in conflict with our right to a speedy trial that we have right in the United States. I think that's one of the amendments, one of the first 10 amendments, right? I believe it's 6, if I'm not mistaken, the right to a speedy trial, part of the Bill of Rights. And what normally happens and what drags these out, though, is oftentimes the defense. Okay, there's a case locally, and I think I made mention of before, and it's very public, so I can certainly talk about it, where a local man is in some hot water over dealings that took place with Rocky Boy and some contracts and those types of things, and that started a couple of years ago. I know some of the defendants in that have already, they've already been convicted or pled guilty. They've already served their time. They're out. They're back to living normal lives and all those other things. But the gentleman here in Havre, he hasn't even had a trial yet. Okay, and it's because of a lot of stuff that's still going on there, right? And maybe his hope is to drag it out just as long as possible for whatever reason. Maybe our memories get soft, and maybe the court system's memory gets soft. I don't know exactly what the strategy is, but it is kind of interesting to follow. So again, we'll talk about each of these as we come up. So pleadings, right? So there's a complaint, and then there's an answer and counterclaims. And again, this is really whether it's civil or criminal. The complaint just depends on who it comes from. If it's criminal, right, it's public, and so the complaint comes from our public, maybe a cop, another officer of the law like a county or district attorney, okay? And then the answer or counterclaims is us, right, or the defendant in a civil action, or us in a criminal action if we've been accused of speeding or something, right? And a default judgment, that's what I talked about a little bit earlier. We can have default judgments when people don't show up. It was common for us at the bank, we'd get folks that, would forget to pay the last $500 of their car loan or something, and they moved to Timbuktu. And so you'd go to court, and you'd file your deal, and they wouldn't show up in court, so you'd get a default judgment. It allowed you then it gave you some legal backing to go and collect on that. That doesn't mean the court collects the money on your behalf. Okay, it just gives you more rights, and you've shown in court that you have a legal right to collect the money, and it gives you more rights to go out and collect that. Okay, you can do some other things when you have that judgment in hand in terms of collection. So the pleadings, again, the plaintiff has the complaint, the defendant's the answer, and then the defendant almost always issues or requests a motion or makes a motion to dismiss to the court. And sometimes they will. I mean, you'll see that occasionally. An attorney might, or a judge might look at it and just say, there's just not enough evidence here or anything, and so, we're just going to dismiss this. That happens. You'll read about that in some court cases every now and then. So your quiz for any court to exercise authority, what must happen, jurisdiction, subject matter jurisdiction, personal jurisdiction, and standing, all three, right? Discovery's the process, it's fun. You guys didn't get to grow up, but boy, I did. You grew up with Matlock and Perry Mason and some of these old lawyers, and they'd go to court, and the trials were always really dramatic and really cool, and they'd make a discovery during the trial, and they'd bring that to light, and the defendant would get off or whatever the case may be. In truth, that doesn't really happen because of discovery. What happens in discovery is all those issues that are going to come up in the trial have to come up ahead of time. And in fact, new stuff just might not be allowed in a trial. Now, might depend on what it is, might depend if it's associated with some of the other stuff you've brought up, et cetera, right? And it makes it more fair. It allows both sides to kind of analyze where they're at, and then when they go to the trial, the issues are kind of delineated, and then we're just going to throw it out here and let a jury decide, right? And some of the things that we might have, and again, part of your homework, I think, was Methods can be interrogatories, which are just questions that each side asks each other, written questions. So you write up questions that you want to ask the other side, and you send it over to them, and they have to do it. Request for production of documents, so there might be documents involved, may or may not be, in a case. But let's say you were suing your former boss for wrongful determination, you'd want to look at your personnel file, and you'd have right to do that, so you'd request that, right? Depositions are they're kind of interesting. They're like a person being called to the witness stand, except you're not in the trial. It's before the trial, okay? And the issues are a little less limited, right? They're a little less limited, so they'll ask even more questions. Now, whether or not the answers will all be admitted, say into the court, it'll be up to the judge at that point in time. But it's a little bit more expansive. I found the times that I've been deposed and all the cases I would depose in regards to the bank when I worked there. But it's kind of intimidating because you're sitting in a little office, generally speaking, with your lawyer, the plaintiff and their lawyer, and the little court reporter guy, that you see in these courtroom scenes, with his little machine. It was always his. I'm sorry. Now there's in Haver gals that do that, but back then all we had were guys that did that, and they're doing their little typey doodad thingy, and away you go. And it's a little bit intimidating, and it can go on for hours and hours and hours, and so it's kind of interesting. And then requests for admission of evidence. So if you've got some evidence, you have to ask that it be admitted for a trial or whatever. Yeah, and this is kind of like the deposition, right? A lot of this stuff it'll be more broad than what's actually ends up being can be used as evidence at the trial. Okay? There's a cost to it, right? My deposition, I had one, and I had to read through it and verify that it was accurate and everything, and honest to God, it was 60, 70 pages maybe. The little court reporter guy, he's got to go through all that, and then he goes back and his court reporter thing puts it on the computer, and they have to go through and change it and whatnot, and then you got to read it and verify, that it's, just think of the time that takes to put that together, the time for me to read it, the copying of the documents, because then there's at least one copy given to the other side, and on, and, attorneys and paralegals involved, and it gets to be very expensive. Some abuses, right? Parties can become aggressive. Again, you're outside the court, really. And the ones that I were in were always extremely civil, never got aggressive or anything. And actually, every now and then you'd stop and have a good laugh or get up and do something, and we were trying to find answers to questions, and it was very civil, the ones that I was involved in. Damage to the litigation process, maybe. Maybe. Again, the ones I was involved in, it certainly didn't, and so maybe sometimes it's hard for me to imagine how that really would damage it, but oh well. Yep, key is to act reasonably and prudently and avoid extreme positions. I guess the abuse would be damage to the litigation. If somebody were actually abusing the discovery process, and in my cases, nobody was abusing it, so. Motions. Questions of law, of course, can come up, right? If there's a statute of limitations, that's a deadline when somebody can actually bring a case, be it civil or criminal. There can be statutes of limitations. Judgment on pleadings or a summary judgment. Again, this is something that the cases that I was involved in, somebody would, a side would always file, generally the defense. Maybe they're the only ones that can, but would always file for a judgment on pleadings or file for summary judgment. And what that meant is, after evidence was presented and before the trial, and the judge kind of had access to a lot of that stuff, you'd file a motion basically asking the judge to dismiss it, that the evidence and whatnot was so overwhelming in your favor as a defense that the judge should just dismiss it. And we had at least one that we were successful in our motion of summary judgment. Unfortunately, that was the one that ultimately got appealed all the way to the Ninth Circuit Court of Appeals. So it was okay. Affidavits, just written statements by folks. Okay. I don't know why they call that a motion, because affidavits are written statements. That's actually part of the discovery process. So Yeah, I should move that one. I don't know why it's here, because an affidavit, you'd have a motion maybe to allow those to be in there, but an affidavit's actually part of the discovery process. And then frivolous cases, and we had one of those. A fella filed a case, a lawyer filed a case against our bank, um, saying bad faith. It was bad. There was a time when everybody filed suits against banks for bad faith, it was called, and we actually filed a motion that the lawyer that brought the case said it was a frivolous case and that he should be censored, meaning put under some kind of restrictions and whatnot, and we were successful in that. So kind of interesting. The processes are interesting, and it's a pain in the butt, when you're right about something like that, and you still have to go through those motions, okay? And it's expensive, and you wish you didn't have to, but how else are you going to settle those disputes, right? And we always try to find cheaper ways, Had the attorney, stepped up and maybe come and talk to us and done some of those things, maybe some things could have been done that would have been a lot less expensive and not caused the heartache, and not cause him to be censored. But jury selection, and you read stuff and you'll see that most attorneys, when they deal with especially criminal cases, they see jury selection is probably the most important part. Civil cases too, I'm sorry, probably the most important part. Picking a jury that you feel may represent your point of view, maybe, or maybe more understanding to your point of view, right? They're given challenges. Lawyers on each side are given challenges, and they go through. You're talking to juror members and whatnot. They can be exempted or kicked off, if you want to call it that, for cause. Right, so if you, for example, if you were asked to be a juror in a murder case and the potential penalty was death penalty, and you were just absolutely opposed to the death penalty, you might get kicked off, right? Okay, and then preemptory. I think each side's given so many preemptory challenges where they can just ask that a juror be dismissed for whatever reason. They just might not think that they're going to be understanding to your point of view. Constitutional violations, you can have people eliminated, right? They've talked about elimination of peremptory challenges. So, there could still be challenges for cause, but peremptory challenges, yeah. I think most attorneys would not like that. Again, this allows them to help to form the jury, probably try to eliminate people. I think what they're doing when they do this is try to eliminate people in the jury that might have extreme views, might be on the edge in terms of their views. That's kind of my guess. So that in '86, racial discrimination was banned in the use of peremptory challenges. So, attorneys have to be careful, right, that they're not just eliminating people. If you got a white person standing trial, and you're asking for a black person to be eliminated from the jury pool, simply because of the race, that wouldn't be right. Okay. '94, gender discrimination was banned in the use. Okay. And that's not very long ago, right? But you might imagine that there are cases, rape cases, different things like that, where prior to, we might have felt that a certain gender might not be able to be completely impartial, and so I can understand why that took a while, right, for this one to be to be banned. So, and we got religion. Right, and kind of the same thing, people with strong convictions, we kind of look at that and say, ooh, why would somebody's religion have anything to do with it? But people with strong religious convictions might, they might tend to be kind of extreme, in their views, right? Okay, so trial, we've gone through a lot of the pretrial stuff. Then we have opening statement, present the evidence, witnesses. We can ask for a directed verdict. Talk about that. Closing arguments, and then instructions to the jury, and then the jury makes a decision, right? Directed verdict, I think, comes up, so I hope again we'll talk about that. If not, hopefully I'll come back to it. But burden of responsibility of evidence, right? In a criminal case, it has to be beyond a reasonable doubt. What's that mean? It means a unanimous decision. Okay, the jury has to come to a unanimous decision in cases. What was one? Oh shoot, who was the fella? Geez, he was just on trial, and it was for murder. It was a heinous case, and the jury had no problems. What was it? It was one of the Boston bombers, Sarnoff, and the jury had no problems finding him guilty. Okay, that was done fairly early, but the jury in that case was also the body that decided the sentencing, and because they couldn't be unanimous on a death sentence, he was ultimately sentenced to life in prison. Now, that's how it works in Massachusetts. I don't think that law is the same in Montana. I don't think the jury in Montana actually decides punishment. I think the judge does, I think, okay? I'm not 100% sure of that, but I think that's okay. So anyhow, criminal cases have to be unanimous, right? So you got to persuade all 12 people, generally 12 people, you know, one way or the other. And there's an excellent movie. It's called 12 Angry Men. It's an older movie. It's black and white, starring Henry Fonda, if I remember right. But it's about that and about their deliberations, you know, really after the trial and whatnot. And it's really it's really a good movie. Civil cases involve just a preponderance of evidence. So, and I think this might change from jurisdiction to jurisdiction, but many times it's simple majority. You know, again, you got an even number, so it'd have to be like 7-5 or something. Some of them I think require, maybe jurisdictions require more like supermajorities, where it might have to be 2/3 or 3/4. You know, 2/3 being 8-4 type of thing. So, okay, and in that case, there's clear and convincing proof. So we say that the burden of proof is less in a civil case than it is in a criminal case. The original O.J. trial, and long before you guys were born, but O.J. Simpson was, you know, accused of murdering his ex-wife and her boyfriend, and it went to a criminal trial, and the trial was very publicized. You know, literally people watched the trial during the day instead of going to work or at work. They'd turn on the TV, whatever. It was a huge deal. Of course, O.J. was a heck of a celebrity at the time. You know, think LeBron James or somebody like that, right? And in any event, he was acquitted or found innocent of that particular charge, but the family sued him for wrongful death. You know, evidence that cases can be both criminal and civil, and they were actually successful in that case. Again, the burden of proof was less, right? They didn't have to get a unanimous decision. They only had to get a preponderance of evidence or a majority decision. Okay. Judgment in the favor of party that won the jury. So judgment, right? So when the jury comes back and says, you know, we find for the defendant, we find for the plaintiff, you know, that's what the judgment, right? Judgment notwithstanding the verdict. So sometimes after the trial, you know, and I think in all my years of reading lots and lots of articles, I've only actually seen this maybe come up one time, but after all the evidence and everything's gone to the jury, maybe the jury comes back with a decision. The losing side might make a motion for a judgment notwithstanding the verdict, and I've seen once where a judge said, yeah, you know, I think that the jury was out of hand in this case. I think the jury erred, you know, that their decision process, whatever the case may be, maybe there was influence, something, and changes the jury's verdict. Okay, almost never, okay, would that happen, but the possibility exists. Post-trial procedures, appeals. Right. Appeals, we don't go through the evidence. We go through evidence, but it's written evidence and whatnot. We don't have witnesses. Okay, we don't go through the whole trial again. Instead, there's oral arguments. So the lawyers do show up and they'll make oral arguments, you know, and then the judge or justices make an opinion. You know, there's a deference to the trial courts, a deference to the fact finding, especially of the trial courts. What they look at here are the laws, for the most part, right? Enforcement of civil judgments can be execution. That doesn't mean we get to kill them. Okay, it means that we can execute, or I said when we get that judgment in hand, then we have an ability to execute or go out and try to take possession of property that the person had or has, in order to pay the debt. And so generally what happened was, if you knew that the guy's last check to you came from U.S. Bank, and you sued him and you won a judgment, okay, you might have that judgment walked over to the U.S. Bank and be presented, and if that person had any money in their account at that time, at that given time, the bank would be obligated to pull that money and pay it to the law enforcement. They're the ones that would have to execute it, and then the money would come back to the bank to pay down the debt or maybe pay off the debt, right? Garnishment was used quite a bit, actually. Unfortunately, if somebody didn't pay you but you knew they were working, you could garnish their wages. Garnishment's very expensive. Okay, there's a couple things. Garnishment, for one, the max you can get is 25% of the person's wage. So if they get paid, let's say twice a month, and maybe they make $1,000, the max you could get is $250 each 2 weeks, or you could get $500 a month, which sounds like a decent amount, but each time you garnish and each time you do that, you have to go through the whole, it's even called an execution process there, but there has to be somebody that serves that to the employer, right? And their fee's like $100, okay? So for each 2-week period you'd get $250, but you'd have at least a $100 fee, okay, for that service provider and whatnot, and maybe other expenses. And so very little of that money would actually come back and be applied to that person's debt. So garnishment was ugly. If you had to resort to that, generally you resorted to that not hoping that you'd garnish their wages forever, hoping that then the person would come and talk to you and maybe set something up. Maybe they would tell their employer, here, instead of going through this process, why don't you just deduct $200 from my paycheck every time, and we'll send it to the bank. Okay. A doctrine of res judicata just says that it's over, it's done. This one's gone as far as it's going to go. This case is done. Directed verdict refers to, good, it does come back. Power of the court over parties involved. Power granted to the litigant to reject jurors. Power of court to order sworn questioning. Power of court to grant a decision in favor of defendant when insufficient evidence is presented at trial. So there you go. That's D is the answer to that one. So you can see in the trial process, if the plaintiff makes their whole case and they get all done, and it wasn't prima facie, it didn't stand on its own, the defense would make a motion, say, hey, we asked for a directed verdict, and they probably do every time, just as a matter of course, and the judge can say, excuse me, I had to sneeze. The judge could issue a directed verdict saying, yeah, you're right. Again, I doubt that that's something that happens very often, but it probably does occasionally. What's class action lawsuit? We talked about that. How do depositions operate? Kind of talked about that. Can you decline? Yes, you can, but you can also be compelled to testify in a deposition. Okay. So there we have it. There we get procedures and whatnot, and it took me a little less than an hour, but close to it. So that's enough time. I wish you guys well. Have a good week, and we'll talk to you again next week.